Hi everyone. We have new legislation on the horizon, probably in late 2024, which will benefit casual workers, agency workers, those on an unpredictable working contract, and it will allow them to make an application to their employer to request a predictable working pattern. So this applies if there is a lack of predictability in relation to the work they do or their pattern. If the change relates to that pattern, and if the purpose in applying for the change is to get a more predictable pattern. There is no definition of predictability other than in fixed-term contracts that last for 12 months, but it's intended to cover those such as casual workers or agency workers where hours are not guaranteed, may fluctuate from week to week, and the contract in place doesn't provide for any particular mutuality of obligation. So in this article, we're going to focus on workers only. There are some slight tweaks in terms of protection for agency workers, but for the purposes of time, we'll just focus on individuals such as casual workers or those on annualised contracts. So the application for a more predictable pattern can relate to the hours they work, the days, the periods they're contracted to work, or anything else specified by future regulations. A worker must make an application stating that it is for a predictable working pattern, specify the change that they want and the date that they want it to become effective. It's been confirmed that this right will only apply after 26 weeks, so a casual worker can't be engaged on day one and then on day two request a permanent pattern, and they have to be employed in the month prior to making the application at some point, so they must have carried out some work for the employer. So as an employer, if you receive an application for that predictable work pattern, you must deal with it in a reasonable manner and notify the worker of your decision within the decision period. So that's within 1 month, quite a tight time scale there. An application can be rejected on the same grounds as flexible working, so things such as burden of additional costs, detrimental effect on ability to meet demand, recruit staff, insufficiency of work, detrimental impact on the employer's business. Now, if the application is granted, a new contract must be provided within 2 weeks with terms and conditions that, taken as a whole, are not less favourable than the existing contract. So it's important that an employer who grants a request looks at the terms and conditions on any temporary arrangement or casual arrangement and matches those as far as possible, and that contract must reflect the change the worker applied for in terms of that working pattern. If the worker fails to attend 2 meetings or 2 appeal meetings, if the request is rejected, the application can be treated as withdrawn. And just as with the new flexible working provisions, a maximum of 2 applications can be made during any 12-month period. So there are some complaints and remedies which again largely mirror the flexible working provisions. If there are procedural failings, a tribunal can issue an award which is just and equitable, but is likely to be limited to 8 weeks' pay. So that's if, for example, we fail to deal with the application reasonably, we fail to comply with certain time limits, or we reject the application on incorrect facts. That claim has to be brought within 3 months of the failure, and the tribunal can actually order a reconsideration of the application as well as compensation. The employee can make a claim for unlawful detriment, so if they suffer some sort of unfavourable treatment or detriment having made or proposed to make an application, or if they've brought proceedings for a failure to deal with the application. Again, that complaint has to be submitted within 3 months, and there is compensation which is just and equitable in the circumstances. And finally, it will be automatically unfair if an employee is dismissed for making an application, proposing to do so, being selected for redundancy on the grounds that they made an application, or for having brought the proceedings that we've described previously. So that will mean no qualifying period of service for an employee to bring a claim, and it's very important therefore that this procedure is taken seriously. Sometimes it is believed that because somebody is a casual worker, for example, they don't have the same rights, protection or force of the law behind them, but it is clear that with procedural detriment and automatic unfair dismissal claims, it is intended that there is some strength behind these rights. As I say, it's expected that this will come into force in September 2024, so accompanying guidance will come out, and we'll probably develop policies that will need to go into handbooks to accompany this as well. If you do need any further advice on this topic, or indeed anything employment law generally, please visit the website chadwicklawrence.co.uk or email employmenthub@chadlaw.co.uk. Thank you.